name is Ursula Marinelli. I'm the director of the Pacific Communities Health District Foundation. The mission of the foundation is to have a positive impact on the health of our communities by raising funds to purchase equipment, build buildings like the one that we're in, and also provide services and education for our communities. And the Pacific Communities Health District is from the middle of Lincoln Beach all the way through Yachats, and then we also service to the Toledo and Siletz area. So I'd like to thank the kitchen staff, Ken Krenzler, our chef, and his wonderful staff for the food that they provided tonight. Hopefully they heard us. Give them that applause. And then I'd also like to thank Brian Haggerty, local attorney, and he's also been a foundation trustee for many, many years. And I'd like to thank Julia Carlson, she is the CEO and wealth advisor at Financial Freedom Wealth Management Group. I want to make sure I say it correctly. And Julia is also a member of our finance committee. So Brian will present 10 ways not to mess up your estate plan, and then Julia will talk briefly about charitable giving in estate planning. We are videotaping. I know we tried to tell all of you as you came in, we're going to be videotaping and put this on possibly YouTube and our website. And so we do need a consent form signed by everybody. If you don't want to be in the video, then just sit behind the camera. Just slide your chair behind the camera and you won't be in it. So we'll make sure we get those from everybody. And then also there is this little form on the table. If you would fill that out, and then just after Brian has finished speaking, then we'll come around and pick these up, and you'll be in a drawing for a gift card to Clearwater Restaurant, a $50 gift card to Clearwater Restaurant. So, okay. And I think that's all I have to say. Brian, thank you.
Thank you. Okay, as Ursula said, I'm Brian Haggerty. I've been an estate planning lawyer in Lincoln County for about 18 years. And since I am a lawyer, I'm going to start with disclaimers. I am not giving you specific legal advice, and I'm not your attorney because we're going to spend an hour and a half together. I'm going to be speaking in generalities, and the business of estate planning, no, I didn't, I'm sorry, I forgot yours. The business of estate planning is very particular and it's very fact-driven. So it may be that something that I say sounds different from what your own estate planning lawyer has told you. In that case, please don't call your lawyer up and say, Haggerty says you're wrong. Because your lawyer may have been looking at some particular facts that cause your situation to be a little different from the general. As Ursula said, we are videotaping, so I encourage people to ask questions as we go, but please do not be specific about your situation or your assets, because there's lots of folks in this room, and we don't know them all, and there are lots of folks who are going to see the videotape, and we don't know them either. Videotape, come on. What am I, 60? There are a lot of people who are going to see the video, and we don't necessarily want to be talking about, I own this, I own that, what do I do? Because you don't know who might find out. Okay. So we're going to talk about estate planning. And the initial thing we want to find out is, what do we mean by that? What is an estate plan? It's a set of legal documents and arrangements designed to accomplish two goals: to transfer your assets when you pass away to those people you want to receive them, and more modernly, it's to make provisions for your financial affairs and your health care while you're alive, but you're not able to manage these things. They say as many as half of us are going to go through some period of incapacity before we pass away. And during that time, you may want to have arranged for somebody to take care of your your stuff and to take care of you when you can't do that. So what do we mean a plan? Now, I'm going to assert that everybody here has an estate plan. Some of them are good plans. Some of them are not so good. Frankly, we tend to go through life. I'm just realizing how old I've gotten and that I've been here for darn near 20 years. You know, where did that time go? And during that time, I've sold a house, I've bought a house, I've opened bank accounts, I've terminated my relationships with other banking institutions, sometimes not in good order. But all of those things may have effects on my estate plan. And so a lot of people have an estate plan that amounts to 20 or 30 separate decisions made at separate times and with separate frames of mind. And they've never brought it all together and looked at what is going to happen, what in total is going to happen when I pass away. And that's really what you need to know. So your estate plan may be complex if your assets are complex or if your family situation is complex. But it all has to work together. All of the pieces need to function as one whole overarching plan. The thing about an estate plan is when it matters, you're not going to be available to say what it was you meant. You are going to be outside of the jurisdiction of the court at that point. You're going to be in the ground. And that means that in the majority of cases, an estate plan can't be fixed. It can't be changed. And it's sad to talk to a family that says, well, that's not what Mom wanted. She told us at Thanksgiving what she wanted. But the documents are the documents. And the thing about, just to take an example, the thing about a will is, it is a great example of hearsay evidence. That's why we're so careful about the rules for signing the will and for having it witnessed. Because it's a document that says what you want, and there's no way to find out whether it, correctly states that or whether you meant something completely different. So your estate plan has to be right. It has to be perfect. Because after the fact, there's usually nothing that we can do. Okay, so we're talking about transferring assets. And that means we have to talk about the ownership of property. What do you own? An awful lot of the time, people will come into my office and they're talking about Mom's house, Mom's house, Mom's house, Mom's house. And then we actually look on the microfilm records of Lincoln County and we find out it's not Mom's house. It may be owned, all too often, it's owned by Mom and her late husband, who's been dead for 15 years, but she either never could bring herself to take his name off the ownership, or she just never got around to it and maybe never even realized it had to be done. Or she may have transferred interests in the home to one or more of the kids, and more about that later. But ownership of property matters, and there are particular rules regarding how you own things. And these rules are completely different from between real property and personal property. Real property is land and buildings. And it is, classically, it's the thing they're not making any more of. But also, we can tell exactly who owns about 98% of Lincoln County, because the Lincoln County clerk maintains records. And yeah, there are some situations where a surveyor screwed up and there's a strip of land that maybe nobody owns. But in general, I can go online to the Lincoln County Clerk's website and I can look you up and I can find out this particular house, who owns it. In contrast to that, personal property, there are actually two separate kinds of personal property. There's tangible personal property, tangible meaning I can touch it. This chair is tangible personal property. And there's intangible personal property. I can't touch it. That would be bank accounts, brokerage accounts, air miles, a lot of contractual kinds of rights and things like that. The way that you own these things depends on the kind of property that it is, and the way that it will transfer when you pass away depends on the kind of property that it is. I actually was looking for an image that would help me talk about real property, and I came upon this, which is a picture of my house while it was being built. Yeah, that's not the way it looks now. It would be relatively uncomfortable given the weather we've been having. But when I put that up, then I realized, is that real property or personal property? The land that it's sitting on is real property, that's for sure. The house, once I got it built and took possession of it and took occupancy of it, is real property. But the way it stands there, I think that lumber is personal property. And who owns it? At this point, I probably own it, subject to the rights of my friendly banker, but the contractor who is actually nailing all that stuff together would assert that until he's paid for it, he owns it. So the point of all that is that this stuff can get complex, and sometimes I get frustrated with people because they think, I want a simple will. Okay, make your life simple, and then I'll write you a simple will. But your life is complicated, and so a simple will might not be what you want at all. The other thing about ownership is you can own things jointly with other people. You may own things, as I do, subject to a mortgage or subject to a trust. So my ownership is not absolute. My ownership is conditional. If I start missing mortgage payments, the bank will one day own my property, and I will not, and I'll be on the street. All right, so all this is leading to, all of these things transfer, and the rules for different kinds of property are different, and there are different ways to transfer different kinds of property. This is kind of a work in progress. I'm trying to develop this matrix to show, so real property, it may transfer, as we say, by operation of law. When I get married, I may transfer ownership of this property to me and my wife as tenants by the entirety. And that means that when I pass away, she would own it outright, just like that. And all she'd have to do is record a death certificate in the county records, and it would be her house. The transfers sort of move left to right. So I might have left a will that says all to my children, but that's too bad. That's not going to capture that house. My wife owns it. By the time it gets over there to that right-hand column, to the will, it's not something that I own. So it's not something that the will is going to transfer. Okay, so the whole upshot of this is things transfer in different ways. You need to go asset by asset down the list of things that you own and answer the question to yourself, what happens when I pass away? For this bank account, what happens? Is there a joint owner? Do I have a beneficiary named? Have I transferred it to a trust? Or will it pass according to my will? For each asset. And then when you get done with that, then you can chart out, okay, this is who inherits all of these things. Is that the right result? An awful lot of people want the simple will. All to my spouse, but if my spouse doesn't survive me, then to my children equally. That's about the simplest will you can get. But then you need to make sure that that's actually the result when you take into account the joint ownership and the beneficiary designations and these other ways of passing the assets. Have I got things sufficiently confused yet? Did you have a question? I thought okay. I thought I saw a hand. Okay, so this brings us to the heart of this. And I noticed that they called this 10 ways not to mess up your estate plan, but I always call it 10 ways to mess up your estate plan. Because in my experience, there are a lot of people who have created an estate plan, and then they spend the next 10 years defeating that estate plan with more of these random decisions that fall outside of where they really want to be with their estate plan. First way to do this is to get married. Marriage revokes your will. There's a statute that says you get married, your will is now invalid. Now that makes a lot of sense. If you're getting married, almost all the time that's a pretty major life decision. You're going to be changing the makeup of your family. You're going to be changing the people who are important to you. You're going to be incorporating a new family or a new person into your family. So it makes sense that automatically revokes your will. If we're talking about a second marriage, or a third marriage, or a fourth marriage, then this requires some very careful consideration, because you may have children from your first marriage, and she has children from her first marriage, and she may have children from her second marriage, and you may have children from your second marriage. And you don't necessarily want to leave things equally to all of these kids. Unfortunately, sometimes things get ugly in a divorce. People walk away mad. I know that surprises you, but it's true. And sometimes the kids walk away mad too. So it may be that you're getting married to your fourth wife and you've got kids from 2 prior relationships, and the first batch of kids don't really like you anymore, and they don't talk to you anymore. Oh no. We're getting angry messages. It's all right. Okay. So getting married, it just is one of those things that you need to sort of set a pick in your head. You get married, revokes your will. Now you are without a will.
Brian, I have a question.
Okay.
If you get married and you own a home, does somehow, is the law in Oregon so that your spouse has to automatically be on your property?
No, and good point. Further down the line, we'll talk about the fact that We have a sort of a bizarre system in the United States. We've got 50 separate sovereign states that are all amalgamated together in this thing we call the United States. Wills and trusts and probate are uniquely a matter of state law. And so each individual state has its own rules. Some of the states are community property states. We're surrounded by them. Washington, California, Nevada, Idaho, they're all community property states. Oregon is not. And from very early on in Oregon's history, we had this idea that women are people, which still feels a little odd to some of us guys, but women are actually people. They can own property separately, and they sort of they have control of their own futures. So, if you move from a community property state to Oregon, you need to review your plan, because now you're no longer under that system where the marital community has its own identity. And so, no, if you get married, you still own what you own, she still owns what she owns. In some cases, for the second or the subsequent marriages, that's a good thing. And if you keep that firewall going, that's one of the best ways to make sure that your kids inherit what you want them to and her kids inherit what she wants them to. But you have to be very careful, because every time you walk into a bank, they're going to assume that a married couple wants a joint account. And you have to stop them and say, no, this is not a joint account, this is me. Okay. Yeah?
If you have property in more than one state, is there a way to go ahead and incorporate all the eggs in one basket?
No. Having property in more than one state is one of the best reasons to use a revocable living trust, which is a will substitute that you can use, but you still have to. Real property is always subject to the law of the state that it's in. So if I own property in California, 95% of my world is subject to Oregon law, but that one piece of property in California is subject to California law. And I need to take California law into account when I'm doing my estate planning. Okay, so on the other side, divorce revokes your will with respect to gifts to your former spouse or appointments of your former spouse as your personal representative. That's personal representative is the term. Everybody loves the term executor, and we haven't used it in Oregon since 1969. But the personal representative is the person who manages your will and takes it through the probate process. So getting divorced automatically revokes your will. And again, this is very common sense stuff. If you've gotten divorced, there's probably a reason, and you probably don't mean to leave anything to your spouse. In 18 years, I've done one will that actually had a gift to the former spouse. So nothing surprises me anymore. So you could, theoretically, you could get divorced and not change your will, but I don't recommend it. I mean, getting divorced, again, is another one of those major life changes, and you need to review your whole estate plan. It's an awful feeling to see the looks on the kids' faces when they realize that the woman that Dad divorced 15 years ago is going to get all of his pension because he never changed the beneficiary designation on that pension. And divorce didn't do it automatically. So beneficiary designations don't necessarily follow that rule. But the will be revoked. But there are other aspects of your estate plan that you may need to actually proactively change when you get divorced. Here's one of my favorites. Putting somebody's name on an account or putting somebody's name on the property, you have my permission to take a Sharpie and go out back somewhere, where you would test a paint color or someplace inconspicuous and write your kids' names on your house. I almost never recommend that you file that deed in the Lincoln County records, deeding property to yourself and one or more of your children. You're not putting the kid's name on the property. You are transferring an ownership interest in that property to that child. That child now owns a part of your house. You need that child's permission to sell your house. If that kid gets divorced, your house is an asset in his divorce. If he runs into tax problems, the IRS is looking at your house because it's something that he owns. Creditors may attach your house. If either of you've made yourself now double wide for identity theft problems. If you run into identity theft problems, your house might be in trouble. Or if your kid runs into identity theft problems, your house might be in trouble. And finally, I'm going to break some hearts in this room, but it rarely makes sense for the kids to keep your house after you're gone. People always want to, it should stay in the family. And I don't know how many of you even remember Pearl Buck, The Good Earth. Never sell the land. Okay, that's a nice theory in China in the 19th century. But it doesn't work real well here. Usually, when we get joint ownership of land among a bunch of kids, there'll be one of them who's perpetually broke, can never afford his share of the property taxes and the insurance and the maintenance on the house. There's one of the kids who wants to sell it, really has something he wants to do with the money. There's one of the kids who wants to rent it out because he thinks that's a great way to make money. And there's one of the kids who's sensible and willing to do whatever the others want, but she can never get all four of them to agree on anything. So, joint ownership of property, I don't recommend it. I have seen exactly one situation. There's a family in Lincoln County. Property is now owned, I think, by 16 or 17 different people. And they all sign an agreement when they inherit, and it works fine. And they're all able to use it as a vacation residence, and it works great. So that's the exception that proves the rule. In most families, joint ownership of real property is going to blow that family up within a very few years after mom passes away. Bank accounts are the same way, incidentally. If you put somebody's name on your bank account, you're giving them that bank account. Your daughter can then go to your bank, withdraw all of your money, go to Vegas and blow it. And there's nothing you can say because you gave it to her. At the end of the day, your daughter might not be that kind of a person, but at the end of the day, you pass away, and then she owns that account, all of it, outright, by operation of law. It doesn't go to your will. You might have a will that says all to my 3 kids equally, but if all of your accounts are in joint names with good daughter, she gets it all, and she can just thumb her nose at the other 2. Yeah.
Are there tax benefits to do one way or the other?
Nope. As a matter of fact, that's a good point. If you imagine the jointly owned property, in order to take a deduction for mortgage interest or property tax, you have to be legally obligated to pay the tax, and you have to actually pay the tax. So if you and your oldest son own the property jointly, neither of you is going to be able to deduct all of that property tax. You'll be able to deduct half. You may pay the whole amount, but you only can deduct half. And that's an excellent, whenever somebody says the word tax, and I respond with a general statement like that, I'm being stupid, because the tax code, my version of the tax code and regulations is that thick, and it's in like agate type, really, really small type. Our tax code is beyond Byzantine at this point, and so it doesn't matter what question you ask about the Internal Revenue Code, the answer is yes, and no, and maybe. So, but I can't think of any tax benefits.
How about the capital gains?
Will versus property, because if you sell it and it's part of the will, isn't that different than if you sell it as part of your property?
It's different in that if I sell my house right now, I get a exemption of up to $250,000 against capital gain. I've never owned a home that would get me $250,000 of capital gain. If my children inherit, they get to take as their cost basis the fair market value of the home on the date of my death. So if they sell it within 6 months to a year of my death, they have no capital gain. Now that's probably not going to be true if we assume that the current Congress is going to do away with the estate tax. That's basically an estate tax rule, and that is one of the major benefits that there is in the tax code for the middle class, and it's going to go away if they get rid of the estate tax. But as we stand right now, you don't want to make a gift during your lifetime. You want to hold that property until you pass away, because then your kids get to, it basically washes all of the capital gain out. In the current environment, too, where for federal estate tax you've got $5.49 million that you can pass during your lifetime, probably none of us are really concerned about the estate tax. But so if you leave it in your estate and the kids get the step up in basis and they get to wash all that capital gain out, that's a big benefit. If you give it to them during your lifetime, they're stuck with your basis. You know, if you bought the house in 1949 for $15,000 and now it's worth $500,000, there's serious capital gain in there. If you make that gift, then your kids sell the property and they pay tax on $485,000. If you hold it until you die, the basis steps up, they pay no capital gain. Okay. Okay, simplifying your plan. I'm a big fan of wills because a will is one document and it can state everything about your estate plan. It controls your estate plan completely. A lot of people go out on the internet and they get information out of California, where probate is a nightmare, or New York, where probate is a nightmare, and they decide, I've got to avoid probate at any cost. And so they start using all these shortcuts, like designating beneficiaries on essentially all of their property. Now they've got a will that doesn't do anything, and they have all of these individual bank accounts that have beneficiaries named. Now that estate plan can work if you are very vigilant and you keep your eyes on that prize and make sure that you've got the right people inheriting the right amounts of money. But it's way simpler to own what you own, no joint ownership, no beneficiary designations. Everything passes through probate in your will. Your will can then say exactly what you want it to say, and it controls things. Yeah?
Does a revocable trust have a priority over a will, or?
The revocable trust, and I think that's actually number 6. The revocable trust, oh, it was number 4? Did I jump over something? Ah, you're right. I don't know how to get back a slide. Okay, if you decide, here's one of the basic decisions you have to make when you're putting your estate plan together. Do I want to use a will or do I want to use a revocable trust? If you decide to use the revocable trust, thank you, you have to commit to the trust because the trust is a contract between you and your trustee. It only affects property that you transfer to your trustee as trustee of the trust. So, in the majority of cases, people who use a revocable trust leave a few things out. They don't get things transferred to the trustee of the trust. Now you have the trust administration, which is going to govern all of the property that is transferred to the trustee, and then you have a probate for all of the property that didn't get transferred to the trustee. So if you decide to go, and trusts can work beautifully. The principal advantage to the revocable living trust is that it provides a management tool during those times when you're incapacitated. It can fairly seamlessly transfer control of your assets to a person that you designate as your successor trustee, and that person can manage your assets, pay the costs of your care, and kind of look after things. And I've even seen in one case the situation where the person regained capacity and took back control of the trust, again, fairly seamlessly. In terms of taxes, there is no benefit to the irrevocable trust. In terms of creditor protection in Oregon, no benefit. Anything that's in the trust, your creditors can get to. So for the revocable living trust, the game is you have to decide, this is the way I'm going. I'm going with the trust. You have to understand the trust, commit to it, and you need to make sure that whoever is going to take over when you're incapacitated or when you pass away, you need to make sure that that person understands the trust and knows what they need to do. And as I say, funding it with some of your things and leaving other things out is kind of the worst of both worlds. Now you have the cost of a trust administration and you have the cost of probate. And you've just kind of doubled everybody's work and expense. Okay, now we're simplifying. And I think I've actually talked my way through that. If you are simplifying things, you need to make sure that you don't sort of subvert your whole plan. Another fairly common problem that I see is the probate that has no cash. There's a house, maybe there's a couple of parcels of real property, but all of the cash has got beneficiaries named. So the real property has to go into probate in order to be transferred, but there's no cash going in with it. And a probate estate is like anybody else. If you don't have cash, you're sort of dead in the water. You can't pay the utilities, you can't pay property taxes when they come due, you can't pay a mortgage if there's one. Somebody has to loan money to your probate estate in order to pay those ordinary expenses. I did want to mention, in terms of beneficiaries, I said that it works well if you have no beneficiaries on anything. The place that that's not true is the retirement plans. Individual retirement accounts, 401ks, 403bs, tax-deferred annuities, all of those things must have individual named beneficiaries. Otherwise, the tax result is really bad. So that's the exception. And when you're making your list of assets for your estate plan, always keep the retirement plans separate. Because an inch or two of that Internal Revenue Code that I was talking about is all about IRAs. I mean, the rules are just insane for those things. And it's always different. An ordinary bank account is always different from an IRA, and you need to plan differently for them. Yeah?
Is that true for both regular IRAs and Roth IRAs?
It's true that it's different. There aren't the same tax problems for a Roth. But that's kind of the illustration. Covered LESAs, Roths, Keoghs. There's a medical IRA. I don't even remember what it's called. There are all of these different kinds of accounts. They all have different particular rules. And you want to make sure that you've run through the planning scenarios with all of those different things. Okay.
Question?
Yeah.
What did you mean by probate cash? Like if you've got a revocable trust, you're not talking about, are you still talking about probate? Or?
Well, no, you're probably not going through probate. But what I mean is if you've got real property and it's going into probate, so you don't have a trust, there's just real property, you've left a will, it's going into probate, there needs to be some money to pay those expenses. And the thing is, it costs exactly the same to probate a $100,000 estate as it does to probate $1 million estate. So you're not saving any money by passing some of your assets outside of probate. Yeah?
Did I misunderstand that you should not have your trust be your, for your IRA
Yes.
plan? You should not.
You should not. If your estate plan is complicated to the extent that you can't simply name individual beneficiaries on your IRA, then it is possible to design a trust that can take the IRA when you pass away and can distribute it. But it is a very particular planning option, and it has to be done right. If you have a garden variety revocable living trust and you name your IRAs, or you name the trustee of the trust as beneficiary of your IRAs, you run the risk of running up your taxes quite a lot, the taxes on the beneficiaries anyway. Okay, here's a big one, putting the wrong person in charge. There's a concept called a fiduciary. A fiduciary is a person who manages property or money for another person. And the fiduciary duty is said to be the highest duty under the law. You need someone who is absolutely honest, completely businesslike, straightforward. You need Sir Galahad to be your fiduciary. Sir Galahad would be the perfect fiduciary, and that's what fiduciaries should be aiming at. Unfortunately, Sir Galahad is not available. Usually you've got a son or daughter who's going to be taking care of things. If you put the wrong person in charge, I don't care how good or how carefully thought out your estate plan was, it's going down the drain. And this can be either the gentleman on the right who's actually stealing, or it can just be the gentleman on the left who's just sort of a clown and doesn't get things done, or does things in that sort of random and, Saturday Night Live way of doing things so that nothing really makes sense from one day to the next. A fiduciary has to be able to understand your plan and commit to your plan. The perfect fiduciary would be the one who can carry out your plan even though he doesn't think it's right. I don't think my brother, John, who's been a deadbeat all his life, should get anything. but Mom left him 1/3, so I'm going to leave him 1/3. As a matter of fact, if we're down to the last dollar, he gets 34 cents. So, and that person is rare. That person is hard to find. A fiduciary, and generally we're talking about the successor trustee if you're using a revocable trust, or your personal representative if you're using a will, doesn't have to be a family member, but it usually is. If there's nobody in the family that you know you can trust to do things right, you can name a professional fiduciary. Usually you can't use a bank trust division because they really don't want to talk to you until you got about $1 million. But there are professional fiduciaries out there who serve in this role for individuals. And frankly, if you've got doubts about your family members, it's best, in terms of keeping the family together so they can continue to share Thanksgiving together, it's best to name a professional fiduciary rather than put someone in charge who's going to not get it right. Yeah?
If you do everything as well as you can, and you have a modest estate, how much work is it for that person that you leave in general?
It can be a lot. The fiduciary has to do a lot of, basically the fiduciary is taking over your life on top of their own life. And that can be a really challenging thing, especially if good daughter lives in Portland and now you're going to pass away and leave property that's down here in Lincoln County. She's going to be driving Highway 20 an awful lot. But she can also hire people to help. She doesn't have to drive down here and mow the lawn all summer. She can hire that done. She can hire local handymen or contractors to do repairs on the house. She can talk to the neighbors and make sure that somebody's keeping an eye on the house. There's a really bad problem all over the state now with homeless people. And if your house is empty for more than about 25 minutes, people will start to move in. And once they get in there, unfortunately, Oregon doesn't have a lot of really solid law concerning how to get them out. It can be difficult to get them out. So you want to make sure with your dying breath that you ask your neighbor to keep an eye on the house and let them know, you know, my daughter Debbie is the only person who needs to be here. If you see somebody else there, please call the sheriff and get them out. Okay. The one that sort of drives me nuts is I'm just going to leave it all to my son. He'll know what to do. Well, no. I mean, he might not. It might not be your son who ends up actually managing this estate plan. It might be a fiduciary for your son. And why not actually just say in the documents exactly what you want to have happen? You give me a will that says exactly what you want to have happen, and I know I can make that happen. If you give it all to son John, he may end up with tax problems because now all of a sudden all of the income in the estate is taxable to him. If he's fairly wealthy, he might have a problem with estate taxes because he's going to have to be distributing property that will be counted legally as his, and he'll have to make gifts. The other well, there are a variety of different kinds of side deals that people sometimes want to get into. Well, I'm going to leave the house to my 3 kids, but everybody understands that my daughter will live there until she passes away. No, that's going to irk the other kids no end. because they're going to be paying property taxes and maintenance and insurance and all of these costs on this house, and they're going to be waiting until sister dies to actually inherit anything. If you want a toxic situation that'll blow a family up, that's one for you right there. If that's what you mean to do, put it in the documents. Then at least it's not sister's fault, it's your fault. And they can't hardly complain about you because you don't care anymore. Okay. As we said, we have 50 states. There are 50 sets of rules. They are similar, but there are a lot of states that came out of Spanish civil law, and they have community property, and they have other aspects of civil law that applies. There's Louisiana, which is different from everything. Louisiana's laws are just different from everywhere else in the world. And even states where the rules are similar, there may be one rule that will catch you. And so if you move to another state, you need to have a lawyer in that state review your estate plan and let you know, is this going to work in this state, or do we need to make some changes? It may surprise you to learn that there's a lot of nonsense out there on the internet. Just nonsense. So if you get your planning advice off the internet, I don't know. You may be getting good advice. You may not. All of the nonsense out there is masquerading as good information. So it's never a good idea. A lot of the forms and materials come out of New York, Illinois, and California because those are very populous places. And their laws are completely different from ours. California, probate is a nightmare. And that's where a lot of the drive for revocable living trusts comes from. Because if you've ever lived in California and been through a California probate, you never want to go through it again. So you'll go with the revocable living trust in order to avoid it. It's just not true in Oregon. Probate is a much more sensible process in Oregon, and so the revocable living trust may be creating a lot more work for you during your lifetime that you really didn't want. But the basic idea is, I have been doing estate planning for 18 years, and pretty much every week I learn something new. There's a lot of information out there. I don't change the oil on my car anymore. If I had to put a new roof on my house, I wouldn't do it myself. I would hire somebody who knows what he's doing. He's got the tools, he's got the knowledge, he's going to get it done easily. It won't be me running a pro build 75 times over a course of 4 months trying to get the job done. It'll get done. Same thing with estate planning. You're better off talking to somebody who knows what they're doing. And finally, just sign it and forget it. You might, I guess one of the benefits of a will is that you can just sign it and forget it, because it's going to transfer whatever you own when you pass away. But in the 25 years since you made your first will, your family will have changed, your goals may have changed, your assets certainly have changed. We recommend that you take your estate plan out about every 3 years and review it, and just make sure that it still says what you want it to say. Okay, so what do you need? You need a list of assets showing the ownership and the approximate values. Now this, I'm almost hesitant to suggest this because this is, of course, identity theft heaven. If you make such a list, you want to make sure that you don't have account numbers or too much specific information, and you might even want to do your estate plan, figure out how everything works, and then destroy it. You need to do the rigorous, list and figuring out how things work, but you don't want to then post that on the internet. This is not something that goes on Facebook. You want to do a family tree. Make sure you're not forgetting anybody. Even people that you deliberately want to forget, it's very important if you want to disinherit a natural lineal descendant, you have to make sure that your will says, I have a son, John, and I intentionally make no provision for him. Otherwise, he can come back and say, well, he just forgot about me. But I'm his son, so I'm a natural object of his bounty, and so I should get a share. You want to actually make sure that your goals are clear. Who do I want to get what? Who do I want to be the winners in this matter? Choose the fiduciaries carefully. And there may be other considerations. If one of your beneficiaries is disabled and is receiving public benefits, you may want to do some special planning for that person, because dropping an inheritance on that person might simply disqualify them from benefits until all that money's used up, and then they have to go back on. Essentially just kind of a waste of time and life. There may be other considerations that come out of your particular situation. There may be, for example, charities that you want to remember. And those kinds of planning goals are actually the next talk. Okay, so I think we've talked about a will. Oh, one thing I want to mention about a will. A will doesn't do anything at all until it is submitted to the court for probate. And probate is actually related to the word prove, to prove. We've proved that this is the last will and testament of decedent. And now we're going to walk it through this process where we give effect to what that will says. Yeah? Then you substitute a set of statutes that are designed to mimic what kind of the majority of people want. If you're married and all of your kids are children of that marriage, then your wife takes everything. If you're married and you have kids from a different relationship, then the wife gets half and your kids get half. If you're not married, your kids inherit everything. If you're not married and you have no kids, then your parents inherit. And assuming they're already gone, then your brothers and sisters inherit. And if they're already gone, then your nieces and nephews inherit. It actually goes out to the lineal descendants of your grandparents may actually take. And for some people, not having a will essentially works. It does what they want it to do. Yeah?
Where does the durable power of attorney fit in?
That's during your lifetime.
Okay, so after the person dies,
The power of attorney's gone, yeah. So that's actually part of the longer version of this talk is actually available from the community college as part of the lifelong learning program. And I'm doing it this term up in Lincoln City, but I'll be back. So if you watch the Catch the Wave publication, you'll see my estate planning class. And we talk then about medical directives and powers of attorney and all those good things. The revocable living trust we talked about, that's a contract between you and your trustee. So it only affects the things that you transfer to that trustee. And probate is that legal process that gives effect to the will. So the will doesn't do anything. It's the power of the state of Oregon that actually transfers your assets. The nice thing about probate is that at the end of the process, a judge signs off and says, this guy's done what he needs to do. This is how these assets are now owned, and we're done. And in almost all cases, that's the end of the story. If you find other assets that need to be transferred, you can reopen the probate. If you've screwed up really, really badly, then somebody else can reopen the probate within 2 years and hang you out to dry. But if you walk through the process right, you end up with that judgment and everything's done. Yeah?
What's
What's the average length of time for probate?
Usually depends on how long it takes to sell the house. It can't be done in much less than 6 months. There's a 4-month period during which you have to search for creditors and make sure that they're paid out of the estate. And given that it takes a little while to ramp up and a little while to ramp down, 6 months is a good minimum. Around here, though, you need summertime to sell real property, and so you're waiting for summertime, find a buyer, then you can close.
If you have a professional fiduciary, how is it determined what kind of fee they get or what monthly?
Their fees are basically, they need to disclose to you what their fees are going to be. And most of them get between $60 and $100 an hour. And then it just depends on how complicated your estate is and how complicated your plan is and how long it takes them to make things happen.
And that comes out of?
Everything in the probate estate is paid out of the probate estate. Yeah. So I'm actually over time, so I need to wrap this up. Thanks for being so patient. And we'll see you later.